Now we discuss Indian polity, basic structure of the constitution. Emergence of the basic structure. The question whether fundamental rights can be amended by the Parliament under Article 368 come into come Article 368 come for consideration of the Supreme Court within a year of the Constitution coming into force. This in the Sarkari in the Sankari Prasad case 1951, constitutional validity of the First Amendment Act 1951, which curtailed the right to property, which challenged. The Supreme Court ruled that the power of the power of the Parliament to amend the Constitution under Article 368 also include the power to amend fundamental rights. The word law in Article 13 includes only ordinary laws. And not to the constitutional amendment acts, constituent laws. Therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a constitutional amendment act, and such a law which will not be void under Article 13. But in the Goloknath case 1967, the Supreme Court reversed. But in the Goloknath case 1967, the Supreme Court reversed its earlier stand. In that case, the constitutional validity of the 17th Amendment Act 1964, which inserted certain states acts in the 9th schedule. Goloknath case 1967, the Supreme Court revised its earlier stand that the constitutional validity of the 7th Amendment Act 1964, which inserted certain states act in the 9th schedule, was challenged. The Supreme Court ruled that the fundamental rights are given a transcendental and immutable person, and hence the Parliament cannot abridge to take away any of these. A constitutional amendment acts also a law within the meaning of Article 13, and hence would be void for violating any of the fundamental rights. The Parliament rejected the Supreme Court's judgment in the Goloknath case, acting for 24th Amendment Act 1951. This act, this act amended Article 13, 368, Article 368 and 13. It declares that the Parliament has the power to abridge or to take away any of the fundamental rights under the Article 368, and such act will not be a law under the meanings of Article 13. In the case of the Bharati case 1973, the Supreme Court overruled the judgment of the Goloknath case 1967. It upheld the validity of the 24th Amendment Act 1971 and stated that the Parliament is empowered to abridge or to take away any of the fundamental rights. At the same time, it laid down a new doctrine of the basic structure of the Constitution. It ruled that the constitutional power of the Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge to take away fundamental rights. That forms a part of the basic structure of the Constitution. The doctrine of the basic structure of the Constitution was reaffirmed applied by the Supreme Court in the Indira Gandhi case 1975. In the case, Supreme Court invalidated the provision of the 39th Amendment. The doctrine of the basic structure, the 39th Amendment Act 1975, which kept the election disputes involving the Prime Minister and the Speaker of Lok Sabha outside the jurisdiction of all courts. The court said that this provision was beyond the amending power of the Parliament, as it affected the basic structure of the Constitution. The Parliament can react to this judiciary innovated doctrine of basic structure by enacting 22nd Amendment Act 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of the Parliament, and no amendment can be questioned in any court of any ground, including that the contravention of any of the fundamental rights. However, the Supreme Court in the Mills case 1980 invalidated the provision of the excluded provision as it excluded judicial review, under which is the basic features of the Constitution, applying the doctrine of the basic structure, which respect with respect to the Article 368. That court held that since the Constitution had conferred a limitation amending power of the Parliament, the Parliament cannot undertake exercise or the limited power of the power enlarge that very power into absolute power. Okay. Indeed, it's the limited amending power of each one of the basic features of the Constitution, and therefore, limitation of the power cannot be destroyed. In other words, Parliament cannot, under the Article 360, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution, or to destroy its basic structure. Basically, the doctrine of a limited power cannot, by the exercise of that power, convert in the limited power into the unlimited one. Again, in the Woman Rao case 1981. Again, in the Woman Rao case 1981, the Supreme Court adhered to the doctrine of the basic structure of the Constitution. Woman Rao case 1981. The basic structure of the doctrine, the court adhered there to the doctrine of the basic structure of the further clarified that it would apply the constitutional amendments enacted after Article April 24, 1973. That is the date of the judgment of the case on the Bharati case. The elements of the basic structure. The present position is that the Parliament under Article 368 can amend any part of the Constitution, including the fundamental rights, but without affecting the basic structure of the Constitution. However, the Supreme Court is yet to defend or clarify it as to what constitutes the basic structure of the Constitution from the various judgments. The following have emerged: the basic features of the Constitution are elements, components, ingredients of the basic features of the Constitution: supremacy of the Constitution, sovereignty, democracy, and republican nature of the Indian polity. The secular democracy character of the Constitution, separation of the powers between the legislature and the executive and the judiciary, federal character of the Constitution, unity and integrity of the nation, welfare state, social economic justice, judicial review, freedom, basic structure of the Constitution, the basic feature, freedom and dignity of the individual, parliamentary system, rule of law, harmony and balance between the fundamental rights and principle of equality, freedom of fair, election, free and fair election, and independence of the judiciary, limited power parliament to amend the Constitution, effective access of justice, principles underlying fundamental rights, powers of the Supreme Court under Article 32, 136, 141, 42, powers of the High Courts under the Article 226, 227, evolution of the basic structure of the Constitution. Number 1. Name of the case here, case on the Bharati case 1973, popularly known as fundamental rights case. Elements of basic structure as declared by the Supreme Court: supremacy of the Constitution, separation of the powers between legislature, executive, and judiciary, republic and democratic form of government, secular characters of the Constitution. The federal character of the Constitution, sovereignty of the unity of the India, freedom and dignity of the individual, mandate to build a welfare state, parliamentary system, India as a sovereign doctrine, and democratic republic, equality of states, and Indira Gandhi case, 1975, popularly known as Election Commission case. Okay, opportunity of the individual secular. Okay, India as a sovereign, Indira Gandhi case, India as a sovereign republic, equality of status and opportunity of an individual secularism and freedom of the conscience and religion, governance of law and not man, rule of law, judicial review, free and fair election, which is implied in democracy. Minerva Mills case, 1980, limited power of the parliament to amend the constitution, judicial review, harmony and balance between fundamental rights and direct principle. Central Cold Springs Limited case, 1980, effective access of justice. Okay, Bhim Singh Ji case, 1981, Welfare State Social Justice. SP Sampath Kumar case, 1987, okay, rule of law and judicial review. AP Shambhu Murthy case, 1987, rule of law, justice, judicial review. Okay, Delhi Judicial Service Association case, 1981, 1994, on Supreme Court under Article 32, 136 and 141 and 142. Indra Sonai case, 1992, popularly known as Mandal case, rule of law. Kumar Padma Prasad case. Independent judiciary. Okay. Kyoto Helen case, 1993, popularly known as defection case. Free and fair election, sovereignty, democratic and republic structure. Raghunath Rao case, 1993, principles of equality, unity and integrity in India. S.R. Bomi case, 1994, freedom, federalism, secularism, democracy, unity and integrity of the nation, social justice, judicial review. L. Chandra Kumar case, 1997. L. Chandra Kumar case, 1997, powers of the High Court under the Article 226, 227. Indra Swana 2 case, 2000, principle of equality, all India Judge Association case, 2002, independent judicial system. Okay, independent judicial system. Kuldeep Nayar case, democracy and freedom, free and fair election. M. Nagarajan case, 2006, principles of equality. L.R. Coelho case, 2007, popularly known as 9th schedule of case. Rule of law, separation of power, principles of essence, underlying fundamental principle, fundamental rights, judicial review, principles of equality. Ram Jethmalani case, 11 powers of the Supreme Court under the Article 32. Namit Sharma case, 2013, freedom and dignity of the individual. Madras Bar Association case, 2014, judicial review, powers of the High Courts under 26 and 27. Notes and Shankar Prasad versus Union of India, 51. Raghunath versus State of Punjab, 1967. Keshavananda Bharati State of Kerala, 1973. Indira Nehru Gandhi versus Raj Narayan, 1975. Minerva Mills case versus Union of India, 1980. Oman Rao and Indian 1981. Articles. Okay. With Central Coalfields versus Jiswal case, 1980. Bhim Singh Ji, Union 1981. SP Sampath Kumar, Union of India, 1997. Peace Samamurthy versus State of Andhra Pradesh, 1987. Delhi Judicial Association Service versus State of Gujarat, 1991. Okay, Indra Sarne case versus Union of India, 1992. Okay, Kumar Padma Prasad versus Union of India, 1992. Kyoto Halohan versus Jachilu, 1993. Raghunath Rao versus Union of India, 1993. S.R. Bomi versus Union of India, 1994. L. Chandra Kumar versus Union of India, 1997. Indra Swane K. Had 2 has Indian 2000. Already Judge Assistant has Indian 2002. Kuldev Nair has Indian 2006. M. Nagaraj has Indian 2006. A.R. Kohilo is Tamil Nadu 2007. Ram Jeth Malani has Indian 2011. Namit Sharma has Indian 2013. Madras Barasan has Indian 2014. Thank you friends, it is complete now this chapter. Thank you.